Hello, and thank you everyone for joining us today. I'm Patrick Miller here with the California Lawyers Association ESG section YouTube show. And today I'm really excited because we've been joined by Howard Fischer. He's of Moses and Singer LLP, and he's going to talk to us a bit about the proposed SEC climate regulations and just a lot of the work that he's doing helping companies get their practices in line with the coming regulations and some of the other things that the U.S. government's asking. So, Howard, thanks very much for coming on today.
My pleasure. Glad to be here.
Okay. So we spoke about this a bit before, but I just wanted to ask a little bit about your biography and how it is that you came to be at Moses and Singer and how you became focused on the SEC's ESG regulations.
Well, before I was at Moses and Singer, I was at the SEC for 10 years in the New York regional office as a senior trial counsel, prosecuting a lot of the post-credit crisis cases. One of my claims to fame is that if you've ever seen the movie The Big Short, I prosecuted two of the people in that movie. I'm a little disappointed that the Brad Pitt character wasn't chosen to play me, but what could you do? And so my background is in regulation and enforcement. And so I left the agency a few years ago before it really moved into the environmental regulatory phase. And it's just fascinating to watch it because it is very strange and very atypical and completely unusual for a financial services regulator to be proposing a very large suite of rules that are designed to improve environmental disclosures.
Yeah, that is quite interesting. And I mean, we talked about this a bit. So the SEC has these proposed rules. There's still a relatively long way of actually being passed and adopted. But I think one of the main focuses of these rules is just ensuring that investors and companies understand that these climate rules are now material. There's always been rules prohibiting against false disclosures, but there might be a question as to what disclosures are material. The rules set this out in detail, but you could argue that it's already the case that climate disclosures are material for a number of different companies. There might be a few where there's a gray area, but for a large amount of companies, they're almost already subject to some of these requirements.
Yeah, I mean, I think there are two responses to that. The first is that the SEC has taken the position that climate impacts are material, even if a company itself doesn't believe it. And in one of the, when the rules were first proposed on March 26th of last year, one of the commissioners issued a statement that said, climate issues are existential. Therefore, it is material for every company that's a public company to disclose what it's doing about its climate impacts, how it's treating them, and how it's accounting for that. So on one hand, this is simply the SEC coming in and saying, given the situation that we find ourselves on this planet, this is material for everyone. The second is that it's not super unusual for the SEC to specifically delineate what is material. We have plenty of rules where companies have to disclose certain specified metrics, and adding climate impacts to those metrics is unusual. But on one hand, because it is imposing a definition of materiality that some companies internally might not have. But on the other hand, the SEC has historically said that certain things like workforce counts, certain revenue projections, accounting issues are always deemed material. And so this is following in that tradition.
So one question I have, are you familiar with the FTC's green guidance?
Yes, which I think are also under advisement now. The FTC is reassessing them as they do periodically to see that they adhere to what is currently required.
Yeah, the old green guides have a lot of talk about fax machines and portable phones. No, I'm just being silly.
Yeah.
But no, I think the last green guides were issued in 2014, and they're very serious about revising those standards. I asked because if you think about the FTC, they seem to regulate and help to ensure that representations to consumers are honest and credible and
Right.
things like that. Whereas the SEC, they regulate representations to investors and ensure that they are credible. Do you think that there or is there already in a type of SEC green guidance available for companies or for advisors to help companies make their
Well,
green guidance?
I think that that's one of the factors that's motivating the proposed rules is, it's not that the SEC wants to copy the FTC. Trust me, as a former SEC employee, I can tell you the SEC sees itself as the federal agency, the first and most primary federal agency. So they would never admit to copying another agency. But I think what this reflects is an extension of climate issues across the federal government. I mean, one might expect that the EPA would be taking the lead on this, that the EPA would be saying, here's what you have to do, here's what every company has to do, because that's the Environmental Protection Agency. That's what their obligation and that's what they're supposed to do, leaving aside whether the Supreme Court will allow them to do it. But what you have is a variety of different agencies taking parts of that role. So you have the Department of Labor issuing rules about what pension funds can invest in and how they are going to treat ESG investments by pension funds. You have the FTC regulating or trying to regulate what companies can tell consumers and customers about what their sustainability impacts are. And now you have the SEC coming in and proposing rules that will set out a guideline for companies to discuss what their climate impacts are, what their metrics are, how they are going to deal with climate change, and how they measure what their metrics are, what they use to measure their impacts. If are they using outside accreditation agencies? What is their methodology? So it's part of a green approach that is permeating multiple federal agencies, not just the SEC, not just the FTC.
And in the context of some of the state legislators' backlash against ESG legislation and things like that,
Right.
would it be fair to say that maybe we'll put the DOL, the Department of Labor, to the side, but with respect to the FTC and the SEC, their regulations aren't designed so much as to advance ESG goals or to help companies or to incentivize companies to enshrine ESG goals, but more to the point of if you're already marketing to investors or consumers your ESG capabilities, you have to do that in an honest, credible way. Is that fair to say? Or
I think that is a fair statement in large part, but part of the regulatory push on the federal level is not just reflecting the fact that companies are making all sorts of assertions and wanting to make sure that there's some kind of clarity about the honesty of those assertions. It also reflects the belief that ESG goals, especially sustainability goals, are important. And as the SEC said in enacting in proposing the rules, these are existential issues. And interestingly, it's not, what's interesting is that this approach permeates pretty much everything the SEC has been doing. So for example, it's not just these proposed rules. Recently, the SEC announced changes to its internal guidance about proxy battles. And it used to be the case that if a small investor wanted to put a proposal for vote by shareholders on a non-material issue, i.e. something that didn't really impact the company's operations, the company could easily say, we're not going to include that. We don't want to have that. That's just going to muddy up the shareholder vote. Now the SEC has taken the approach that climate issues are so important that they should be included on many shareholder votes, which is not just a rule, that's an internal interpretation of an existing rule, and now they've taken a different interpretation of that.
Let me ask you a question. Just based on your experience at the SEC, are there certain type of enforcement patterns that you might expect, or enforcement priorities, or anything like that?
Yeah, I mean, so in the enforcement context, cases come about several ways. First is they're reactive. Something happens. So of course the SEC has to react. There's a major accounting fraud. A company has a press conference and says, whoops, when we said we made $3 billion last year, what we really meant was we lost $2 billion. And there's a reactive case that comes in. The other kind of case is a case which reflects a priority of the SEC. So for example, green cases are a priority. The SEC created an ESG task force in the last couple of years, and government task forces are often like Chekhov's guns. If you recall Chekhov's comment about guns, if you have a gun on the mantelpiece in a play in the first act, by the third act, it has to go off.
Yeah.
Government task force are like that. The SEC has staffed a group of people from the enforcement side to look at environmental issues. There already have been several cases. There are going to be more cases. This is a priority for the agency. And I think we are really at the beginning of the phase where we're going to see many, many more of these cases coming down the pipeline. There are already, I hear stories about multiple investigations in this area, and we're going to see a lot of different cases. There are going to be cases against public companies for misrepresenting their environmental impacts. There are going to be, and there already have been, cases against investment funds for misrepresenting their investment metrics, whether they're really using a sustainability matrix when they make investments or not, whether that's just puffery. And this trend is only going to continue and get more intense.
That's a really interesting point I wanted to get to, as far as delineating between what's puffery and what's material. And are we anywhere near having some really codified guidance as to what delineates puffery from real representations that are actionable?
I mean, there's probably never going to be that guidance because there's always a line. And defendants always say, I wasn't making a clear statement. I was making just a general statement about my green bona fides, that we think the environment is important and that we're going to do things that promote environmental concerns. And there's always a line that gets drawn somewhere. The easy cases where someone says, or a company says, for example, when sourcing our raw materials, we make sure that we use renewable resources. That's either true or not true. I mean, you could argue on the margins, but that's a statement of fact. Or an investment company says, whenever we make an investment, we look at the climate impacts of that investment. We want to make sure that if we have different alternatives, we're going to choose the one with the lowest climate impacts. And then the internal messages of the company's investment advisors show that no, actually, they're not doing that. They're looking at what investments or what portfolio companies have the highest returns. So while there is some gray area in general, it is pretty clear sometimes which statements are just puffery and which statements are statements of fact, which, if not true, can be the basis of an enforcement lawsuit. And let me just add that we just saw 2 days ago I think it was 2 days ago, a class action case filed against Delta, based upon their statements about their environmental impacts. And Delta will no doubt argue that whatever its statements were, they were generalized statements, and they're probably not going to use the word puffery, but they'll say something like they were statements of intent, and we're really trying to do the right thing here. These are not misstatements of fact.
And would you think, from a regulator, obviously every regulator is different, but would you think that regulators would obviously gear towards statements that are obviously contradictory rather than statements that could be arguably puffery? Is there a type of matrix when you think about an enforcement action, as far as, who is the actor, how reprehensible are the actions that they've taken? What's the scale of the damages that have been created because of their actions? Are there a few different kind of variables that you would think of?
Yeah, I mean, look, anytime the SEC brings a case, unless it's an emergency, and there's a small segment of cases that are emergencies, something that collapses or at the verge of collapse, a fraud
Like
that
the
needs to
global
be stopped
financial system
immediately.
that you are involved in.
Right, right, right. But in large part, most of the cases that are brought are the result of I don't want to say lengthy because that's a value judgment, but an intense and extensive investigation of the facts with multiple people from multiple departments looking at it. The SEC is not going to say, "Oh, look, I just saw an ad in the New York Times or a commercial, in a halftime of the NBA finals in which you're talking about your green impacts." They're going to do an investigation. They're going to examine all of those factors that you set out. And it's not that there's a list of factors that the SEC looks at and does an exercise in checking the box. It's a qualitative and a quantitative analysis that a lot of people take a lot of time in working on. And every case that I was involved in reflected an enormous amount of work and thought by staff, by supervisors, and by multiple departments. And I am going to assume that the environmental cases that are being investigated now and that will be investigated and brought in the future are also going to reflect that kind of hard work and examination of all the background factors.
And we talked about this a bit offline, and I wonder if you have anything to add to this point with respect to capabilities. So most of the SEC staff, they're securities lawyers. They might not have ESG experience by trade. Do they liaise with, say, the Department of Energy or the Department of Labor? Are there task force staffed by multiple departments?
There are very rarely intra-agency arrangements of that sort. I mean, the SEC works with other law enforcement agencies. It works with the Postal Office. It works with the FBI. It works with the Department of Justice, various U.S. attorneys' offices, state-level actors. But when it comes to substantive expertise, the SEC, it's not an environmental enforcement agency. While there are probably a few people who have PhDs in environmental science at the agency, I'm assuming that's a pretty small minority. On the other hand, the SEC does have the ability to work with and contract with multiple experts in multiple fields as they see fit and as they need. But you do point out a good point, which is that a lot of the enforcement lawyers don't have that background. And so, the question of what is necessarily material or what is necessarily misleading becomes or might become an issue for experts. And, those experts have to be from outside the agency, because when it comes to climate science, I don't know if there are many inside the agency with that background.
But that's not something uncommon for us litigators. So we're both litigators by trade,
Yeah.
and it's very, very frequent where I'm in a commercial litigation with a client that's in the petrochemicals industry or oil
Right.
exploration, or it could be anything. And that's why you have experts who come in and give expert testimony. Presumably they're giving expert testimony for the arbitrator, for the judge, or the jury, but the process of their preparing their expert reports, you become an expert and you learn to ask them questions because you as the litigator are translating their expert evidence to an audience of one, maybe a judge or an arbitrator. So you're that conduit. So you become an expert.
And it's not just in presenting cases to a fact finder, it's in determining whether or not to bring a case. When I was at the SEC, there were a lot of cases that I brought or was part of where there were certain aspects of the case that required an expert who had understanding of the industry or the business in which the case was brought. And so we would consult with experts before we brought a case, because it's not just a matter of saying to the judge or whoever the fact finder is, here's someone to help you figure out that something's gone wrong or been done that violates the securities laws. It's also a matter of figuring out whether or not a case is justified. And you shouldn't bring a case unless you believe it is. You don't leave that for the trier of fact or the judge to find. And so you bring in an expert at an early stage of the case during the investigation if you need it, so that you have that background info.
Yeah, in the context of some of the work I do in my day-to-day law firm role. So we do commercial litigation and arbitration, and sometimes we'll speak with claimants that have a potential claim against a respondent where they're looking to secure litigation funding or arbitration funding.
Right.
And that's a similar issue where you have to do an assessment of the facts and the technical issues and all those things beforehand. I would imagine it's similar in the context of SEC enforcement or regulatory enforcement in general, where the regulator says, do I want to spend the next 2 years of my life working on this issue? Is this
Right.
something that's worthwhile?
Right. I mean,
So,
every case that's brought involves an element of discretion. Is this case worth bringing? And obviously, if a case involves a lot of money that's lost or really bad conduct, the answer to that is very easy. But there are cases on the margin where you think, okay, this case is going to involve an enormous amount of expertise, take years, take a lot of time, a lot of personnel, and might not involve that much of a significant issue. And in those instances, you have to make a determination, is it worth it to bring this case? And sometimes the answer might be no.
so I wanted to move on a little bit, less in the work that you were doing 10 years ago and more into the work that you're doing now and some of the type of problems that you're helping companies deal with as they're on this journey. Are you more focused on helping companies address regulatory issues after they've occurred, or are you more focused on advising companies so as to ensure that regulatory issues don't come to their head?
Well, unfortunately, or maybe fortunately for me, since I'm a lawyer, a lot of the cases we work on are cases where there's already an investigation or there's already an enforcement action that's been begun. And obviously that's a large part of what any SEC lawyer on the defense side does. What is more useful for a client is not trying to bail them out of trouble after they've gotten into trouble, but trying to prevent them from getting into trouble in the first place. I think it's pretty clear, at least it's been in my experience in talking to CSOs and other people in similar positions at some of the largest companies, the Fortune 100 companies, that they have been working on these issues for some time. They have task forces, they have workflow systems set up, they've tried to figure out what the new rules are, what they're going to be, and how they're going to respond to them, how they're going to comply with them. Where I think the gap is in a lot of smaller and mid-sized companies where they don't have that much of an internal regulatory or compliance function. And so there needs to be an element of education. And part of that is made more complicated by the fact that we don't really know what the rules are yet. I mean, we know what the rules that were proposed, those have been published, and we have a pretty good idea that some rules are going to ultimately be published in the Federal Register as the final rules, but we don't know exactly what those rules are going to look like, although anybody who's been following this can make some pretty good educated guesses. So part of the task of a securities lawyer, especially one who understands how the SEC thinks from the enforcement side, is communication. It's trying to figure out how to communicate to companies what's going to happen and how they can deal with that in such a way so as to avoid an enforcement case or an investigation in the near future. And it's not just public companies, it's also companies that may want to be public. It's companies that may want to be an acquisition target for a public company. Right now, if you want to be acquired by a public company and you have significant client impacts, but don't make any efforts to measure those impacts and have no idea how to do it, that makes you a less attractive target for an acquirer. And that's something that damages your value. And I think that's, one of the other interesting things we're seeing now. And one of the things that I think lawyers can be more focused on is seeing climate impacts as a financial asset or liability. And, it's a new way of thinking. And it's a little odd that we treat climate impact as a finance impact, but if you have significant climate impacts and you don't measure them, or if you don't have a metric to measure it, that affects your performance, it affects your valuation, it affects whether or not you could do business with public companies that have to account for their partners' climate impacts, and it affects whether you're going to be acquired by a potential public company that cares about this stuff.
And bringing it back to a point I mentioned earlier, because both you and I have been involved in these issues for a number of years, we do speak that language, and so we are able to say, well, you need a taxonomy for your metrics for evaluation of all of your targets. You need to have a reporting framework to support all of your statements, so you can have almost a footnoting system. We're familiar with those on a day-to-day basis. That even if the company has an in-house counsel, which might be a commercial lawyer that's focused on drafting commercial deals, maybe protecting their trademarks and IP issues, but they don't have the base of knowledge with respect to ESG advisory work.
Right. I mean, in some ways, this is totally new because it's treating climate impacts as a financial aspect of company performance. But on the other hand, it's something that companies have always done. You've always disclosed your liabilities. You've always talked about assets. You've always dealt with accounting issues. This is just adding another item to those already established buckets.
Yeah, I hear I have friends at GRI, so Global Reporting Initiative, they talk about double materiality quite frequently.
Yeah.
So this is just saying there are two different prongs of materiality. Are there any specific kind of areas that you're interested in advising on companies, maybe with respect?
Yeah, one of the interesting areas that's just, I mean, it's always been an issue, but it's been in the news recently, is the idea of accreditation. Many companies, you don't have internal expertise in measuring climate impacts. So they rely on outside experts to say, okay, you're going to engage in an offset program. For everything you do, for every plane you fly, you're planting an acre of trees or not cutting down an acre of trees in, the Brazilian rainforest. Recently, the CEO of one of the largest independent accreditation agencies on climate impacts was forced to resign. And there's been a series of reports that the offset credits that company provided certification for were speculative at best, misleading at worst. So on one hand, companies are being asked to do a lot more. They're being asked to confirm their impacts. And if you don't have that kind of internal expertise, you're going to rely on an outside expert. But on the other hand, you don't have a way of checking the work of that outside expert. So I'm not sure what companies are supposed to do. You're supposed to hire an auditor who checks the methodology of your climate accreditation agency. And then you have, a fleet of MBAs and PhDs, checking their work. I mean, the SEC's proposed rules account for the use of outside experts and think that that's actually a way of promoting reliability, because it's one thing to say, here's what we're doing, and it's quite another thing to say, okay, it's not just what we're doing, here's what other people say that we're doing, so trust us. But all it's doing is outsourcing the essential function of corporate disclosure to someone else. So I'm not so sure if that solves the problem or if it just creates another problem.
Well, then you get into the Arthur Anderson, you get into Sarbanes-Oxley, you get into how we're going to determine the credible auditor, so to speak.
Right. I mean, look, this is one of the interesting things about securities regulation, is that effectively securities regulation is the idea of coming up with rules that govern the way that capitalism works and how stakeholders of different kinds are treated. And it's really complicated. We have a really complicated system, really complicated systems of labor, of production, of corporate organization, of finance, and coming up with rules that provides all of the information that you need is really, really hard. And what I think the accreditation issues show is that it's really hard to solve for one thing without creating a problem in another area.
Yeah, it's a question of whack-a-mole. And so our part as company advisors is also to understand that we have to be kind of two steps ahead of the regulation. We have to know what the status of the regulation is,
Right.
have a framework and a history to understand where the enforcement, where the patterns are going towards.
Yeah, and it's not just that, it's not just regulatory impacts, it's litigation impacts. Anytime you're sued by the SEC, within 20 minutes after the filing of that case, probably before, there's going to be a class action case. There's going to be a derivative case filed in Delaware or whatever state you're incorporated in. And so it's not just a matter of limiting enforcement impacts, because the agency can't hit everything. It's like whack-a-mole, except imagine the board with 10,000 holes, 500 moles coming up, and only a couple of mallets. They don't have the resources to go after everybody. Class action plaintiffs, on the other hand, have the resources, have the interest. And so, as we see with the Delta case that was just filed, it's going to be, it's one thing to avoid regulatory attention, but for every regulatory investigation or enforcement case, there's probably going to be 5, 10, 20, or 50 class action or other forms of private litigation.
Yeah, I was going to ask, have you been involved in any shareholder derivative suits where it might not necessarily be a public company, but it might be even a private sale where a key issue was environmental issue? Yeah.
Yeah, I mean, I've been involved in a lot of these kinds of cases, not in the environmental area, but I think one of the interesting things about this is under Delaware law, there's what's known as the Caremark decision, and it governs what corporate officers and directors are liable for. And there's this idea that if you are if you are responsible for something that's mission critical, you have a heightened duty, and it's easier to bring a lawsuit alleging negligence and failing to adhere to monitoring a mission critical aspect of corporate life. I think we are seeing a shift in viewing environmental issues and environmental impacts as having that kind of centrality to company management. So I think we're going to see in the next few years multiple cases involving director liability in an environmental context that we might not have seen in prior years.
And it becomes a kind of virtuous circle where the more CSOs that are elevated to the board level, then you can argue it's more mission critical. And then if it's more critical, you have to elevate CSOs. And
I mean, the irony is the more attention you pay to these issues, the more credence you're lending to the argument that they're mission critical, and therefore the more you might potentially be exposing yourself to liability.
Yeah, which is an interesting balance that you have to strike on. I was having a conversation with somebody recently where I was discussing in the context of managing your human rights and environmental issues with respect to your supply chains, and we'll get onto scope 3 emissions in just a moment. But in the context of helping to eradicate human rights and forced labor from your supply chains, oftentimes companies will take more of a collaborative approach with their suppliers, which would come up to the point of almost saying that they're taking on some duty of care. And you as the lawyer for the company need to manage that potential liability to ensure that there is a discrete separation between the parties. So you manage that liability, but at the same time, if you create such a separation such that the company can't have any positive effect on the ground, you open them up for risk for other liabilities. So.
Right. I mean, it's a very strange balancing act, because on one hand, if you have no involvement whatsoever, you can be accused of shutting your eyes to an obvious problem.
Yeah. Yes.
On the other hand, if you have a ton of involvement, you could be accused of being complicit in what your suppliers or your downstream companies are doing. And so the hard part is finding the balance between involvement and guidance without basically running the show. And it's a hard balance.
Mm-hmm. Yeah. And, not to get off on too much of a tangent, but I'm reading this book right now about how economists measure the value that different sectors contribute to the economy. So how do you measure the value of the financial sector? Economists in the past, Adam Smith, David Ricardo, used to think of landowners as not providing any value. So throughout history, there's different conceptions of what adds value to the economy. oftentimes people say, if you're producing something, you're adding value to the economy. And many times throughout history, economists have said that lawyers create no value for the economy. But
which I've heard from clients.
yeah, yeah, that's yeah, to get it even less abstract. But the point is, we're at a system where the economy is so complicated that you need lawyers to help negotiate these very complicated issues. So we do add some value.
It's like going on a road trip through a labyrinth without a GPS.
Yes.
Lawyers are the GPS. We live in a very complicated regulatory system, and there are plenty of ways you can get lost.
Exactly. That's a great metaphor. I like that. I might steal that. I hope
you can
nobody's.
steal that.
I hope. Unfortunately, we recorded this, and now it's.
Oh, well, I'll just charge you a penny anytime you want to use it. It's pretty cheap.
Perfect.
I've given you a license.
There you go. Okay. So now another point that I wanted to talk about is the potential impact for non-US companies or non-public companies of these proposed rules on Scope 3 disclosures. So maybe first, you can give a little bit of a breakdown of what Scope 3 disclosures are to the non-initiated, and then you could talk about how that implicates some different aspects.
This is to me is a very interesting aspect of the SEC's proposal. So scope 1 and 2 emissions are the greenhouse gas impacts of a company's direct and indirect operations. So for example, if you have a power plant on site, what greenhouse gases does it use? If you have employees commuting to work, what are their greenhouse gas emissions if they take the cars that they have versus taking the bus or the subway? Scope 3 emissions, on the other hand, are what one SEC commissioner has referred to are the effects of other people. They're downstream users, they're of counterparts, corporate, commercial counterparties, customers. Is what happens when you either buy the stuff that you use to make the stuff that you sell, and what happens when you put your goods out into the stream of commerce. And part of the SEC proposals, and again, we don't know what's going to be in the final rules, and this has gotten a lot of pushback, so it might be watered down somewhat. But one of the proposals is that certain companies, the largest companies, will have to account for scope 3 emissions. And while some of the people say, well, it's only a small subset of companies, it's not the majority of companies. It happens to be, I think, 2/3 of the corporate asset by value. So it's the largest companies that control a large chunk of the economy. And this is interesting for several reasons. First, as I alluded to before, it means that even if you're a non-public company and thus not subject to SEC disclosures, if you're doing business with a large public company and they need to roll up your emissions and their scope 3 disclosures, well, congratulations, you're effectively now regulated by the SEC. You want to do business with a large public company? If there are 3 potential competitors, all of which provide the same product at roughly the same price, but one of them says, oh, look, here's a form that says, here are our scope 3 emissions. Here's what you need to, if you want to just roll these up into your disclosures. That company now has a significant competitive advantage over the other non-reporting companies. Let's say you're Ford Motor Company, I've just picked them randomly, and you're getting rubber for tires, and you're getting the rubber from a rubber plantation, potentially from Brazil or from Borneo or from somewhere else. Now, those companies that are non-public companies that are outside the US now have to have some kind of reporting and disclosure mechanism if they want to do business with a public company. And of course, there are ways that a public company could say, well, we're just estimating what they're doing. We're using the following metrics to figure it out. And we take the responsibility for doing that. But in large part, again, you have the same factors. If you have multiple opportunities across the globe to pick suppliers, but some of them have a reporting mechanism in place and a disclosure mechanism in place, that gives them a competitive advantage. And that's odd because now you have non-public companies outside the US effectively subject to SEC regulations.
And are there similar? I mean, there are. I'm asking this as a question, but and there are obviously similar reporting and disclosure obligations coming from the EU right now,
Right.
probably from Asian countries as well, and it's a similar thing. So we're not focused on the EU regulations as such for American corporations, but you have to be because you're selling into the EU market.
Right, and you see this. You see the same thing in supply chain regulations. If you are an EU company subject to forced labor disclosures, perhaps you don't have to worry as much about U.S. companies. Although, as you and I, I'm sure both know, there are plenty of legislative initiatives in many states that may make the U.S. subject to that kind of reporting issues in the future. That's a subject perhaps for another discussion. But it points to a globalization of these kinds of reporting regimes.
Yeah, I mean, in a complicated global economy that we have now, the regulatory regimes have extraterritorial effect. That's just by its nature, even if that's not the intention, it's the function. Okay, this has been a really great conversation. We've really moved through. Are there any kind of final thoughts you have as far as where you see the future and ESG and the law coming together? A lot of that we've kind of talked about that throughout.
Yeah, I think the one issue, and I think you referenced it earlier, is the anti-ESG efforts that are underway in several states. So, you have places like Texas or Kentucky, or states that have an extractive resources-based economy, which have taken a very defensive posture on ESG issues. So, for example, Texas has come up with a list of overly woke companies. And those companies include companies like UBS, for example, which allegedly is against the oil industry. And I don't want to get into the issue of what metric is being used to define some company as woke or not. I think the Kentucky Attorney General has issued a series of subpoenas to multiple financial companies, asking them what their approach to fossil fuel extraction is, whether they're financing it or not. So, on one hand, you're seeing this push for ESG action and ESG disclosure, but on the other hand, large chunks of the economy, and Texas is a pretty large state, are taking the opposite approach and saying, not only don't you have to disclose this or deal with it, but we think these are bad. We think these are immoral and they're culturally inappropriate for our state. So you have a company like UBS, which gets on Texas's bad list and now can't work on public offerings of local debt. These things have real consequences for companies that get on one of these, anti-woke lists. So this is a new and strange front in ESG issues. It's unclear how they're going to develop. I don't know. It's been a while since my constitutional law class. But if the SEC issues a set of rules, I am not clear as to whether or not they may preempt contrary state regulation on these issues. But I think this is going to be an area for courts for a long time to come.
Yeah, and it'll be an interesting area for us to watch. Well, thank you very much for coming on.
Oh, my pleasure. Thank you for having me.
It's really quite fascinating to speak with somebody who was in the enforcement context and is now in the advisory context, and your dual roles really give a fantastic insight. I really appreciate you.
Oh, thank you. Thank you. Thank you very much.